Simkiget, Sigamanak, Wilsatu, Milu Witlaksa, Michael Harris. What I just give is the Gitsan greeting to all the chiefs, to all the chieftainesses, and to all the precious little ones. Just said my name, he who dances in the clouds, passed to me by my Smogan, my Simkiget. So her name is Wigach. And so we welcome you here. We give thanks to all the First Nations around here in Kelowna and giving us permission to come and do our work. And I'm from Gitsan Nation. And so we'd like to welcome everyone here and we'll just say a quick prayer, words of gratitude. You can stand now. Great Creator, we just pray to you and we thank you for all things. We praise you for your grace, your love, your patience, your understanding, your strength, your teaching, and your protection. Creator, we thank you for helping us, guiding us, so that we could let go of all our pain and help us heal in heart, soul, mind, body, and spirit. And ask you to help us to be gentle with each other as we meet here with issues are very close to our heart, with regards to 60 Scoop and everything that entails. And we ask you to guide us and keep us safe. And we thank you for the food we eat, the water we drink, the love and hands to prepare the food. I hate all my relations.
Good afternoon. My name is Stephanie Naka, and I'm the Okanagan Director of the 60 Scoop BC region. I'm a First Nation 60 Scooper from Manitoba. I'd like to introduce the lawyers, but before I do, there's just some housekeeping rules. First and foremost, this is strictly an information session, not the space to tell your story. Not that your story doesn't want to be heard, but just because they have information to hand out. And if you have any questions, by all means, when we're done, just ask. They will answer all of your questions. Note the exits of how to get out of this building, and then the washrooms, I'm sure is down there somewhere. Yeah, they have to have washrooms up here. Thirdly, I'm a third-year psychology student at the University of Okanagan. I'm majoring in psychology and Indigenous studies. So if you ever need to reach out to me after this, I'll make sure you have my card and then you can just give me a call. I'm not a licensed psychologist as of yet. I'm probably 18 months away from my BA. Lastly, I'd like to do a land acknowledgement. So I'd like to acknowledge that we're on unceded ancestral and currently occupied territory of the Silks people. Correct. As a group here, we recognize that we have continuous work to learning, unlearning, reflecting and acting towards decolonization, reconciliation, and centering and celebrating the Indigenous knowledge, peoples, and leadership. So with that, I'd like to present Simona and Ivana from the law firm Jellinek, Ellis, and Gluckstein. Gluckstein. As their professional lawyers on some of the most sensitive cases ever that people have endured in this country. So please feel free to ask any questions, even online. You're welcome to type your questions in the chat. They will be answered. And for now, Simona and Ivana.
So thank you very much for coming and for having us here. My name is Simona Jellinek. I am senior counsel at Jellinek Ellis Gluckstein. And I have had the privilege of helping Indigenous clients my whole career, which is almost 30 years now. You can see all the gray hair. I also had the very huge honor of helping the majority of the claimants from Walpole First Nation, which is in Southwest Ontario, for their Indian residential school applications and IAP process. So I've had a lot of Indigenous clients. I am always in awe of all the various cultures because there's so many of them and they're all beautiful. And I think it's just wonderful to be allowed to help. And we hope to bring a lot of information to allow people to make healthy, good choices so that they can continue on to their healing journey. Ivana.
So I'm Ivana Iwasaki. I'm an associate lawyer at Simona's firm. So my role with Simona's firm is, as I was saying earlier, is I often have a day-to-day carriage of client files. So I wanted to come and introduce myself so everyone could get a sense of who I am. So if anyone ever needs me for anything, then they know who they're talking to on the other side of the phone. And I'm here to also assist with providing information, especially for 60 Scoop survivors, but truly for any survivors of especially childhood violence and abuse, to make sure that they know what their rights are and that they have options for things like justice and reconciliation and closure. And I want to make sure that people have that information so that they know what they can do for themselves, and when they're ready, that they have those options. Thank you. And we did bring some tobacco ties. Would either of you like some tobacco? Just, thanks for being here today. Yes. Thank you.
These are the questions. So it's to- this is also not gonna help.
Thank you. Language.
You can't bring up the questions.
No, I know. I can bring them up.
Cool. So one of the most common questions that people have asked is this a class action suit? As we had one, right? Were you guys part of it? I was not. My brother was, but I was not. So, yeah. But does this have anything to do with the class action suit?
This is not part of that class action suit. This is not a class action. We believe fundamentally that class actions are not the best way to deal with abuse cases. One of the things that's really important, and there's been a lot of misunderstanding out there, is that the 60 Scoop class action only dealt with the government of Canada and the cultural harm that was done as a result of the 60 Scoop. So the payments that were received, the $25,000 payment, was from the government of Canada for their role with regards to cultural loss and only cultural loss. It did not include anything at all for the abuse, the physical and sexual abuse that was suffered while in care of child welfare agencies throughout Canada. So this is what we're talking about now. We're talking about what people can do over and above that class action. We are not doing this as a class action for two reasons. First, as I mentioned, we do not believe that class actions are a viable option for abuse cases, because people's voices aren't heard when they're part of a class action. They have no ability to really tell their story, to really make decisions as to what's best for them, to really get the kind of fringe benefits, if you will, that a lawsuit actually allows if it's an individual lawsuit. If it's an individual lawsuit, you're the one who's in control. You're the one who says yes or no. You're the one who tells your story to the people that actually will listen to it and will be part of that settlement. That is a very empowering process. So we don't think it's good to do it a class action because of that, but also because from a purely technical point of view, given the fact that we have all of the provinces that we have, and all the provinces have different welfare systems, child welfare systems set up, some of whom have children's aid societies like Ontario, for instance, and whatnot. And with a multitude of insurance policies that cover all of this, it is actually feasibly impossible to do these as one big class action. So apart from the fact that technically it's next to impossible to do, I'm actually kind of happy about that, because it means that people will not get sucked into a class action where they no longer have any ability to do their own case. So not a class action.
One of the other questions is, so if I receive money from the class action, can I still file an abuse claim?
So the answer is yes. So the class action specifically dealt with one specific harm that happened to people, which is the loss of cultural identity, heritage, history, language, just that piece of it. And even more technically speaking, it only reached a settlement with respect to the Canadian federal government's failures. What we're talking about is that people who have been abused in care or in a different situation as children. So for example, by teachers or by priests or coaches or anything like that, despite the fact that they may have received compensation from the class action didn't compensate people for harm they suffered from abuse or trauma. So it's a separate harm that happened to them that wasn't compensable. So we're going around to make sure that people understand that that's different, because we understand that as part of the class action, that was not made clear. A lot of people understood that it was a kind of a one and done situation, and the $25,000 is all that anybody would get, but that's not the case. That is for one type of harm, but not for a lot of the harm, especially harm from abuse and trauma that people suffered in care, in school, things like that.
Okay. So, let's say if abuse happened a long time ago, can you still use it?
Yeah, you can still sue. In almost every province in Canada, in BC here in particular as well, for sure, there is no time limit to bring a case for childhood sexual abuse or childhood physical abuse.
Mhm.
So whether or not this happened, last week, last month, last year, 10 years ago, 50 years ago, the opportunity to sue for that abuse is still open to you.
What is sexual abuse? What does that look like?
Yeah, so sexual abuse specifically refers to any non-consensual touching that happened to a person who's for some reason rendered incapable of consenting. So we know, for example, children at law can't consent to sexual contact. So if anybody abused a child, touched them sexually as a child, they weren't able to consent to that, that's considered sexual abuse. There are also some circumstances where, as an adult, if you're sexually touched by somebody in a position of power or authority over you, that can be considered sexual abuse too, because the ability of the person in the lesser position of power, so to speak, is compromised. So their ability to consent is not as obvious as it would be between people without that power imbalance. So sexual abuse refers to where that may go on for some period of time, but it can be as infrequently or as often as one incident of sexual assault that occurred that can count as sexual abuse.
Can you explain touching?
Yeah, so touching means it can be either the person has touched a sexual part of your body or they've touched you with a sexual part of their body. So this typically means like genitals or breasts, and really it's also about the intention of maybe touches or things. And I don't want to get too graphic, but it's really the intention behind physical contact between people. So if the intention behind the contact between people is obviously sexual, so for example, if I were to put my hand on somebody's thigh, that could be construed as, sexual contact or sexual assault or sexual abuse.
And sometimes physical abuse, like spanking, for instance, can be considered sexual abuse if it is done on certain parts of the body as well.
Yeah, and so we're mostly talking about sexual abuse, but physical abuse is the same idea. It's just where there's not a sexual connotation to it. So it's non-consensual touching of a person's body in a non-sexual way.
What is considered institutional sexual abuse?
So institutional sexual abuse refers to when the person who actually did the assaults was somehow part of an institution that was somehow involved in that child's life. So for child welfare, so for instance, if the person who sexually assaulted you is your foster father, for instance, then the institution behind that placement, the child welfare agency, would be considered the institution that we would be suing, because it's not just suing the individual who actually physically touched, but also the institution that could be responsible. So for instance, if it was a teacher, then it would be the school board, for instance. If it was Boy Scouts, it would be Boy Scouts of Canada. If it were a coach, It would be whatever the sporting organization is. So that's what we refer to as institutional abuse. And that's important for us because in many of these cases, the actual perpetrator, the actual person who did the physical harm is likely dead, because this happened sometimes decades and decades ago. Or even if they're not dead, they really have no money. So we have to see where it is that we can find responsibility in law elsewhere. And that's usually the institution that put that child in harm's way. That's institutional sexual abuse.
Excellent. Okay, so another commonly asked question is, can I pursue a civil claim? Let's say if the police were not notified of the abuse, or if a criminal case was dismissed or resulted in a not guilty verdict.
Yes, so the civil justice system and the criminal justice system are two different legal systems. So even if somebody has not reported any abuse that they suffered or an assault that they suffered to the police, the civil justice system may still be available to them. So that may be an option that would still work for them. Even if there's an acquittal, even if police are given a report but they don't file charges, even if there's a not guilty verdict, they may still have the option to proceed with a civil case. So we want to emphasize people shouldn't feel discouraged or deterred from looking at this other option if the police didn't listen to them, or charges weren't laid, or even if charges were laid, they didn't proceed with pressing those charges. There may still be an option available to them. So that doesn't need to happen. And we don't need the police to believe them in order to proceed in the civil system.
Excellent.
Yeah.
Let's say, what if there's no witnesses? Like, this happened to you in a room, in a house, no one was around. What happens then?
Well, most cases of childhood sexual abuse are done in secret. Sexual abuse, especially sexual abuse of children, is a crime of power that is usually perpetrated in secret. You don't go around telling people that you're abusing your kid, and you generally don't do it in public. Or if you do it and there's somebody else in the house that has witnessed it, it's usually an intimidation factor that the other person would never tell. They're too scared, whatever else. So very rarely do we have witnesses. Very rarely do we have a situation where somebody comes forward and says, oh yeah, I saw so-and-so sexually abuse that child. Once in a while it happens, but rarely does that happen. That is not in any way a bar to proceeding with an individual lawsuit. Because individual lawsuits are individual and talk about what happened to you specifically, your whole life gets brought into the process. And most survivors of childhood sexual abuse follow somewhat similar life paths. You know, things can be different, but they often will exhibit similar issues. Not everybody has the same issues, but you know, there's clusters of things that we look at. So it really does come up to your, you know, your history and your ability to tell that history. And we gather information in order to help support all of that. But just because there was no witnesses does not mean you don't have a case. I can count in, you know, almost 30 years, I think I can count on one hand the number of times that I actually had witnesses come forward and say, yes, I saw so-and-so do it. Not a problem.
Awesome. Could I abuse, or could I sue, let's say, if my abuser's passed away?
Absolutely. And that's because, well, you can possibly sue the institution that was involved. If there were an institution involved, you can sue because the institution is also responsible. If there's no institution involved, then in most situations, there's nobody to sue because the person is dead. If the person has passed away very, very recently, within the last 2 years, then you may be able to sue the estate of the person who died. So if there's an institution, it's generally not an issue. If there isn't an institution, it's very difficult to sue.
Okay. What's the process of going through an individual sexual or physical abuse case?
So typically, with most law firms that do this kind of work, most people, when they contact a law firm, the first thing that we'll do is we'll investigate the claim to see what people's options are. So the investigation can involve a lot of reading of records. I often joke that we need to see every single piece of paper made about an individual in order to assess their case, but that's really not far from the truth. So we know that these kinds of injuries, these kinds of traumas, and this abuse that happens to people, it's not just a physical injury, right? It's an emotional and spiritual and psychological injury. So it affects the whole individual. In order to properly understand what a person's options are, I have to know basically everything about that person. So as part of our investigation process, I try to look at every record that's been made about a person. So child welfare records, medical records, educational records, employment, income. And then once I have that record, or sometimes even before I have those records, I also want to interview a person about basically their entire life. So I want to know what happened to them, but I also want to know what they were like before, what they remember from their childhood, what's gone on since, how it's affected them, and where they are in their life now. Once I have an understanding of, as much as I can, that person's life history, then I'll have a good idea of what people's options are. Typically, and because we're lawyers, a lot of people will have the option to proceed with a lawsuit. And so I'll explain that process a little bit. If at the end of this investigative phase, we see that one of the options that's available to somebody is to bring a lawsuit, the next step is to start the lawsuit. So file it with the court and serve it on all of the responsible individuals. So this might be the abusers or their estates. This might be child welfare, the provincial government, whoever it might be that's being sued. Once all those people are involved, typically we'll have an initial conversation with them to get a sense of what their view of the situation is. And so we can understand what sort of challenges we'll be facing. Once we have that, typically the next step is to exchange evidence. So we will present them with all the evidence that we've collected, and they'll be required to present us with any evidence they're required to give us. So this typically includes a often more complete child welfare file, for example. If we sue a child welfare agency, a student file or a social worker file from a school, it just depends on who it is that we've sued. And then once we've all exchanged the evidence and had a chance to review the evidence, then typically the person who started the lawsuit, they have the opportunity to tell their story. So they're brought in by the defendants, and they're asked a bunch of questions, but they're also then allowed to and able to tell their full story to whoever it is that they've sued. So a lot of survivors, we find this both very scary, nerve-wracking, but it can be a really empowering process to know that somebody has to actually listen to and face what it is that they did, especially failings. So we make sure that we prepare our people. We make sure that we know they have supports in place, but we think that it's a really critical part of the process, because just like I need to interview somebody to understand them, I think it's important that they understand who this person is too. And the best way to get that across is to actually talk to them. So once that's done, typically we'll have another conversation with whoever's been sued, see if we can reach a resolution. If we can't, then typically we'll go to a mediation, which is like a facilitated conversation, typically facilitated by a specialist lawyer who understands this area of law. And if we can't resolve it at the mediation, then we'll proceed to a judge-led kind of mediation called a pretrial conference, which is where typically a judge will look at the body of evidence, and then she'll say what she would have decided the case, or what she would have decided about the case. And that can sometimes facilitate a resolution. And then if that doesn't work, then a trial becomes necessary. I want to emphasize that we have a really high success rate of not requiring a trial to resolve cases. We have a really high success rate of getting a resolution without needing to put somebody on the stand or in front of a judge or in front of a jury, because that's a really stressful process. And I wouldn't want to put somebody, especially somebody vulnerable, in the middle of their healing journey through that. But go ahead. Yeah.
I was going to say, to emphasize how rare trials are, in all of Canada, there's been about 3 child welfare cases that have gone to a full trial. So they just don't happen.
It's just not needed.
It's just not needed in most situations. Cooler heads prevail, if you will.
Yeah.
And child welfare ends up offering enough money that it makes sense to settle.
Yeah, so that's the typical lawsuit type process. Sometimes at the end of the investigative process, there are other options that might be available to people. It depends really specifically on the individual, what their other options might be available to them. So, but this is like the general route that we take.
One thing that I want to talk about is the purpose of a lawsuit, and the purpose of a lawsuit. The only real purpose of a lawsuit is compensation. The lawyers, the judges, the only thing that we can do for a survivor is to get them compensation. And that compensation in an individual case can sometimes be very significant and generally more significant than what they would receive through a class action. And that's important to know. But the compensation, how much ever money you get, it's really important for people to appreciate that is not the value of their life. That is not the value of their suffering. It is a symbol that we have come up with to basically say, what happened to you was wrong and it wasn't your fault. That's what it is. It's great that we can get you a bunch of money, but the money in and of itself is not going to change anything for people. The money in and of itself may be something, a vehicle for people to get therapy and to get, proper housing and to get whatever, creature comforts. They pay their bills and food and whatnot, but it will not magically take away all of the pain. It is one step in that healing journey. We have found that a lot of people, because this is individual, because they've stood up for themselves, because they've taken control, look at that and really start to grow from that, are able to take those next positive steps in order to find the healing that they need. We try as best we can to talk to people about what they're going to do with the money, because we've all heard of those stories where people get a bunch of money and bad things happen, or they get a bunch of money and suddenly it's all gone because everybody comes out of the woodwork. So we do try to talk to people about what they're going to do with the money, have a plan in place for them, offer them things that they may not have thought about as to what to do with the money. And we try to do all of that well before they actually get the money, so that people are thinking about it. And ultimately, I can say that a lot of our clients do have really good plans in place for afterwards, because they've thought about it and we've tried to help them put that in place. But that's part of what we try to do. And we've found that the majority of people do see it as a stepping stone, and that's why we do this. So,
if I can interject here a little bit. When I first came to Kelowna, I spent a couple of years being a financial broker, and I had a super bad relationship with money. So I changed it around and I ended up having a really good relationship with money and how you pay your bills. So you don't, I don't have to work right now, going to school, I can just work on school. But having just a simple conversation about what you're going to do with money, how you're going to maneuver it, and what's best for you, your own triggers. So if you're honest with yourself and you're honest with who else can help you with it, then the money part won't scare you as much. I have talked to some Indigenous people who are like, $20,000 scare me. Like, it's still sitting in the bank, I'm not touching it.
Yeah.
And I'm like, really? I'm like, wow. And for people who have been poor majority of their life, a lot of money can be intimidating, even if it's 10,000, 20,000, 30,000, whatever it is. They just don't know how to act, and it intimidates them. So, maybe they do have to go on something like a structured payment,
Yeah, absolutely. There are options out there available to people who do individual lawsuits that aren't available to the general public, and one of which is called a structured settlement. And what that is that you can take a portion of your settlement. You don't have to put all of it in. You can take a portion of your settlement, and essentially it's a glorified insurance policy / RRSP type of thing, where you put the money into this structure. You outline at the outset the kinds of payments that you want to receive that make sense with your life. So for instance, some people want an extra, call it a couple of $100s a month. Some people know that they don't need it, but they know they also don't have a pension, so they just want to put it away for their retirement and start getting the money when they're older. You can set all that up at the beginning, and purchase this product, and it'll start paying out. The benefits of something like that is that it's absolutely guaranteed. It is not dependent on what the stock market does. It's not like mutual funds or anything like that. It is 100% guaranteed by the insurance company that it's placed with, by an insurance conglomerate, and ultimately by the government. So even if the insurance company goes belly up, there's still a group of insurance companies who will cover it. Even if they all go belly up, the government will essentially cover it. The other really amazing thing about it is that it is absolutely 100% tax-free. The money that you put in is tax-free. The money that grows within is tax-free, and the money you take out is tax-free. And that is huge, because that makes it almost always better than putting it into a private investment fund, because even if you put it into something that you don't pay taxes on while it's growing, like an RSP, for instance, when you take the money out of an RSP, you pay taxes on that money. If it's in a structure, you never pay taxes. So those are the kinds of things that we talk about with people prior to them getting the settlement, so they have a chance to think about whether or not that's best for them. You know, we encourage them to go talk to their financial broker. We generally don't encourage them to go talk to their bank, because their bank really can't offer the kinds of products that make sense for most people. So we try to, tell people, go talk to a financial broker. Oh, you don't have one? Here's a list of 3 people. You want to do this? Here's a list of people. You want to do a structure? Let's set you up with an appointment with that structure broker, because not everybody can do a structured settlement. You have to have a particular kind of license that very, very few people have in order to do that.
Yeah. And if you don't have one, call me.
Yeah.
I'll send you in the right direction. I no longer do it because I'm a university student, but I still have some connections out there to some good firms.
Yeah, and we have connections with other people as well, people that have worked with our clients before, and we've gotten really positive feedback with how those financial brokers have helped our clients.
Sorry.
So this works basically like so
The financial?
the money that they aren't receiving, is their interest that they make on it?
In the structure? Yes, absolutely. So
Yes.
what happens is that it's placed and it's completely outlined as to the interest rate that you're going to get. It is either a fixed interest rate, which is whatever the interest rate is at the time, or it's indexed to inflation. So depending on how you set it up, I mean, it is completely individual, and the person that we use to do our structures, she literally will spend days working with somebody to make sure that they have the plan that works for them, and it could be very, very flexible. I've got one client, for instance, who gets a little bit of money every month, but on his birthday, he wants $1,000, just as, happy birthday to me.
Yay.
Right?
Excellent.
That's how she
Best
set it
birthday
up.
gift ever,
right?
but yeah.
We've got a lot of them where it's like, I want a little bit of money, but I want to make sure that when my child goes to university, there's money there for the kid going to university. So we know, give or take, when the child is going to turn 18 and go to university, and there's a lump sum payment to help with those university costs. So you can tailor it completely. Yeah, it's a really good product that is only available to people that have had individual lawsuits.
So I just want to ask a question, like, how long does it take for lawyers to investigate your options for justice? on physical or sexual abuse? Like, how long would it take?
Yeah, so it can take anywhere from a few months to sometimes, I've had one that has been honestly going on for 3 years, but it's because of the nature of the work that we do. So we do historical abuse lawsuits as our primary focus. So what we normally focus on is we focus on getting records that were made 20 or 30 or 40 years ago as our first step. So child welfare files, you know, we've had child welfare files and we've gotten them from the 50s and the 60s and the 70s, but sometimes it takes a while for those to come out of the archives. Or if somebody was placed in a group home, maybe we need to get those from a ministry or a central database or an archive. So I have one file where I've been trying to identify the corporate identity of certain group homes for several years now because I've just been chasing them down because they've been closed for so long. And I have some files that they come in within 2 months. I know everything I need to know. We've, for some reason, gotten their child, they already have their child welfare file, so we're good to go. So it depends on each individual case, but typically I say on average, people should expect about 6 months before I get to a point where I can give them some kind of assessment. And then if it's longer, I try to let them know to expect that it's going to take longer and explain why.
Would it help if we ask for our records? Like,
Sometimes, yeah. So
okay, like
sometimes,
if we know where we're adopted out of or where we're fostered or whatever, we can go to those vital statistics of that province and say, can you please send me my file? And then at least we have a copy and maybe photocopy for you guys.
yeah, so that can for
Speed up
sure
the
speed up the process.
process?
Yeah, so it can help if, especially if, so it's different laws that we trigger. It's the same system. It's just that we're one step removed from you. So you have to get authorizations and so on and so forth. But most people have a right to access their child welfare file if it's about them. But sometimes it's easier for us to get the file if the person is, and I don't want to say unsophisticated, but maybe not up to speed on certain tech that the
Or
child
just doesn't
Yeah.
want to.
or just doesn't want to. I have a client who I said, I want you to get the file. And she said, no problem, totally fine. I didn't think to tell her, you don't have to read it. So she had it in her head that when she got it, she had to read it. And she called me, she said, I can't do this. And I said, no, you absolutely do not have to read this file. Please send it to me. Just no, don't stop looking at that. So if it's easier for people, we're happy to do the request too. Yeah.
Okay, okay, good. That's just something that.
And that's actually something that I want to touch on as well.
Sure.
Because these are individual cases, we try to accommodate people as much as we can. So, you know, there are some timelines that we can't shift around because they're court dates or whatnot.
Mhm.
Those are difficult to shift around. But, you know, if somebody is supposed to meet with us and they're having a really bad day and don't want to meet with us, then that's okay. We get it, you know. We try as best we can to make this as easy as possible for people. It is not an easy thing to do. I wish it were. But we try as best as we can to accommodate and to make it as gentle as possible, if not easy.
Painless,
Well,
painless.
yes.
Try to be
We
as
try to
painless.
inflict minimum pain.
Right?
That's the
Yes.
goal here.
Okay.
Yeah.
So what if the adult who was a child doesn't know where to start? They know that they were apprehended.
Yeah.
They know they stood maybe in front of a judge, and they don't know where to go.
Sure. That happens a lot. So that's a good question. And it's difficult to tell you because sometimes when people talk to us, they'll say something that will tell us where to go.
Yeah.
They may not know, but something that they're saying triggers in us, oh yes, that's this or that. So even if you don't know a lot, it's surprising how much you actually know when you're being asked the right questions.
Mhm.
And even a little bit of information can lead us to the right places. So the best thing to do is to contact either us or other lawyers that you feel comfortable with and go from there.
That's why it's important to note that this is a specialized area of practice. So there's not a lot of lawyers that do what's called historic sexual abuse. So lots of personal injury law firms, lots of lawyers will say we do assault, we do sexual abuse. But it's important that when you have a situation like this where you know maybe it was 20 or 30 or 40 years ago and they don't have a good memory because they were 6, and how are they supposed to know what the name of the courthouse is because you're 6 and you're trying to play with trains? Like we specialize in this, so we know how to ask at least the right questions to get us pointed in the right direction. And not all lawyers understand that. So certainly people don't have to come to us. That's just something we do. People have the right to choose who their lawyers want to be. But if they come to us, like I know we have a records clerk that should be a person, like a private investigator in my mind, because the things that she's found is just incredible. And when we set her on something, more often than not, 9 times out of 10, she will find it. So, and she's good that way. And when I do these life history interviews, there's a reason why I say I need to know everything about you, because maybe you say, oh, I spent 20 minutes, or maybe I spent 2 years at this school, and I say, what's the name of the school? And all of a sudden I know that you're in this region, which is governed by this municipality, which has this child welfare agency, and you were, born in 55 and you were 6 when you were in this, and all of a sudden I know where to go, who to ask, what ministry to contact. So that's why it's important that the lawyer knows about historic claims.
So what about the person who walks in and because of their trauma, there's big pieces missing from their life, they don't remember.
Sure.
Or there was so much pain, they no longer want to or are able to recall. So where are they?
Again, it's really becomes an individual thing. You don't have to remember everything. In fact, most people don't remember everything. If you remember absolutely everything, you either have one of those incredible memories that almost nobody has, or we wonder. Most people remember certain things, but there's lots of blanks. That is not how human memory works. So it's absolutely okay if you don't remember everything. You don't have to remember, if you were 5, maybe you were 6. You just have to remember that you were somewhere around there. You were little, You don't necessarily have to remember exactly how many times something happened. Most people, especially if it is ongoing abuse, cannot remember how many times. Was it 10? Was it 12? Was it 200? But most people are able to remember enough that that's what we can go on.
Yeah. And that's another part of the interviewing process for me anyways. I've had clients who come in and they say, I know this happened. And then so I walk them through it. I say, okay, you let me know if you need a break, but let's, I need some details. So let's walk through this. And we work through it together. So we either, I help the clients put the pieces together, or if they don't, the law recognizes that, sometimes people forget stuff. Sometimes people don't remember stuff, which is a key difference. Or, the law recognizes that when you're being traumatized, when you're in a traumatic moment, your memories are not formed in the same way. And so the law actually recognizes that you can't, traumatized individuals can't recall memories, sometimes chronologically, sometimes in the right order, sometimes they have the wrong spatial awareness. So a capable lawyer, in my opinion, will take that and they'll say, okay, I know what the limitations are. I know how the law works. I know how the rules of evidence work. Let's work together so that you have the options available to you that you need to have available to you for that justice and that closure. And they make it work.
Here's one that's a little bit sophisticated. So we're looking at a potential client to come to you and they say to you, actually, I wasn't taken by the government and I stayed at home. But what happened was I had 2 siblings who were taken by the government, and through their experience, there's a lot of sexual exploitation, and they brought that home with them.
Mm-hmm.
And as a result of them being sexually active and promiscuous, they're now using their siblings because that's what they learned in 60's Scoop.
Right.
Yep.
And they brought that home. Now, 2 siblings have passed away, but the damage is done to the 2 siblings who are at home. Is because we know of cases where we have families at home, but you know what I'm saying.
They learned the act somewhere else.
Of course.
And brought it home.
Of course.
How does that work? Or is that someone going to be able to work with that?
Yeah, so this is part of the reason we can't do something like that, like a class action, because each individual circumstances is so specific. So, as soon as you came up with this, I'm thinking, okay, well, I have a lot more questions that I want to ask, right? I want to ask, was child welfare still involved with the family? Did they know what was going on? Did they know what happened in the original home? There's a lot of information that I need before I can tell somebody if they have the option to still do something about it. So that's part of what I think we want to emphasize today is it's, you know, even if something is complicated or strange, or you're unsure, we don't want people to feel deterred from investigating whether or not they have this option.
So at least come and talk to you
Yeah.
and say something,
Yeah.
at least tell you the story and
Yeah.
then make,
Yeah.
you know, don't just
Don't just
stay
assume.
home. Don't just think you're not gonna listen. Don't just think you
That's
don't
right.
have a case, because you very well may do.
Yeah, that's right. And
So-
I've seen Simona take disparate pieces of information and say, here you go, here's the whole package. And all of a sudden, it's like the sun broke through the clouds and we say, okay, here are our options. Let's just go. And I obviously I think very highly of Simona's my mentor, but she, no, she really, she shows people what sort of options they have in really murky, confusing, difficult, hard circumstances. So it's, you know, we want people to feel like at least they have the option to try.
Yeah, and I mean, I think that that's why we're doing these town halls. We're really trying to emphasize that people do have the okay, if you will, to come talk and see if something can be done.
Yeah.
You know, I want to tell you that we can help everybody. I want to help everybody. We're not going to be able to help everybody, but at least we will listen and we will tell you whether or not there's something that can be done. And, you know, for some people, knowing that nothing can be done actually is a bit of closure. Like, you know, they don't have to wonder anymore. They don't have to wonder.
Yeah.
Exactly, right? And, you know, for other people, knowing that they can do something and that it's a good case is enough for them. They actually don't have to do the case. They just have to hear it from a lawyer saying, you know what, you've got a good case. We can do X, Y, Z for you.
Mhm.
You know, for some people, that in and of itself is very healing. Gives them
Yeah.
power, right? You know, you don't have to use your power to have it, right? A lot of people can start that healing and can start that taking control back, just knowing that they have the power. So that's what we're doing, and this is why we're doing these cases, because there was so much confusion about 60 Scoop survivors and this class action and whatnot that we really felt it as a real responsibility.
Yeah.
to talk to people about what their options are, because knowledge is power, and we want to give people that knowledge. So this is why we're doing it.
Yeah.
So come talk to us, or go talk to other lawyers that know what they're doing in this area. If you don't want to talk to us, we can give you a list of lawyers that may be able to help you.
That we, like, we trust and we
Yeah.
talk to them. We
Exactly.
made sure that they will treat people with respect and dignity and everything that you would always want a lawyer to do anyway.
Okay.
There are a few lawyers in Canada that do historical sexual abuse. Very, very few. There's about this many.
And we've talked to all of them just about.
But we have other lawyers in each province that we feel comfortable that will at least talk to people and treat them with the respect that everyone deserves, and they will then come to us for help.
Yep.
So we're okay with that. If that's absolutely okay, we want to make sure that people are comfortable with the people that they go to.
So just wondering, like, how long do you have to press charges for sexual assault in Canada?
As long as you need. There's no limitation whatsoever to go to the police to press charges. The only thing that will stop you there is the death of the person who hurt you. So, you know, if you go to the police and the fellow is dead, if they track that person down,
Yep.
and he or she is dead, then obviously the police can't press charges against the dead person, although sometimes I wonder if that
Should happen.
should happen anyways.
Make a public statement about.
Make a public statement about
Yeah.
that person.
So in regards to this stuff, what sort of fees are charged by lawyers to assist with the abuse assault?
So our law firm and the law firms that we've talked to and work with, we typically work on what's known as a contingency fee arrangement. So
Okay.
there's no upfront fee, there's no cost. People don't have to actually pay out of pocket for us before we will do any of the work.
Okay.
We will also cover any of the costs and expenses, things like court fees or mailing or process server or printing off paper.
Okay.
Yeah, so we'll cover all of that. And then the fee arrangement is once a settlement is reached, we will take a percentage of the settlement as our fee. So typically our firm charges 33% of whatever the settlement is as our fee at the end of the lawsuit. So once the money has come in from the individual or the insurer or whatever. So, and then the expenses on top of that as well. So that's what's covered. In a lot of settlements, we are able to also get the insurance company or the institution or the government to cover some part of our fee as well. Not always, but that's part of the negotiation we have in trying to get that resolution, to make sure that even it costs the person even less at the end of the day.
I would caution people that if a lawyer asks you for money up front with this kind of case, I would really caution people that perhaps they should go talk to a different lawyer and get a second opinion.
Perfect. That sounds like everybody's budget.
Yeah.
Well, we recognize that childhood sexual abuse can often, childhood sexual abuse has devastating consequences on somebody's whole life. There's not one part of you as a person who is not affected by being abused as a child. So your relationships, both your social relationships, your family relationships, your romantic relationships, your employment relationships, your educational relationships, all of that is muddled. And that means that most people's education and careers get sidetracked. So we understand that most people don't have the kind of money that is necessary to fund the investigation stage of a lawsuit, let alone anything else, which is why they are done as a contingency at the end.
Okay, excellent.
Yeah.
Hopefully that's good. One of the other questions that has come up are like, what sort of supports exist for survivors who want to start a lawsuit?
Sure. We always encourage people to have support when they're involved in a lawsuit. Lawsuits are not easy. Even if we try to be as gentle and as painless as possible, they are not easy. So we always encourage people to get the support of their family and their friends. We encourage people to have a counselor, an elder, a therapist, whatever kind of outside support that they have. We sometimes can help people find those supports. There is there's a 1-800 number and a website available for 60 Scoop members, the class action people, and they will provide support for this, as well as the 60scoopnetwork.org, which is a network out of Ontario, but they provide support throughout Canada, and that's 60scoopnetwork.org. They have a crisis line, but they also have a full page of resources available, and that's throughout Canada.
Excellent.
Yeah. And there's also cultural support available and provided by elders through the Indian Residential School settlement. That's still on, it's still available. You can access that for support as well.
Yeah.
Good. Excellent.
Okay.
Yeah.
If there are any further questions, we'd be happy to take them. I know that there's one online. So somebody asked what the statute of limitations is in the Northwest Territories. I don't actually know those offhand, but if somebody needs to ask us the question specifically, you can contact us directly and I'm happy to look into it. I haven't looked at that one just yet. Yeah.
I'm almost sure it's fine.
So we know that, even if there's something like in most cases, we can make it work. Like in most cases, there's a way to argue it or, look around it or find some way to make it work for you anyways.
Yeah, in most provinces, there usually is a way to move past that. To give you an example, in Ontario, up until about 6 or 7 years ago, there was a 2-year limitation period on suing for sexual abuse. And
Right.
obviously,
Right,
if these happened 30, 40 years ago, how do you do it?
Right.
Well, I've been suing in Ontario for the last almost 30 years for historical sexual abuse cases.
Successful.
And it generally wasn't a problem. In very, very few cases before the law changed, did I actually have a problem in starting a lawsuit.
Okay.
So
That's
So for 1 to 2 years, why did they say that?
It was
Concerns me.
yeah, it's a general 2-year limitation on suing for things like, car accidents and slip and falls and whatnot. Sexual abuse, sexual assault, physical assault sort of fell into that. But there was case law, there was judges realized many decades ago that that's not really fair when it comes to things like sexual abuse, where somebody is often unable to understand that the problems that they're having now are because of what happened to them 30 years ago as children. So we had what's called the discoverability principle. So those 2 years don't start until you discover that it was the sexual abuse that is causing the problem. And it went even further than that. That talked about how, you don't even, you aren't actually even able to realize that until you get therapy and whatnot. So there were lots of ways to finagle your way around that 2 years. So, in most provinces, it really is not an issue. And I don't believe it's an issue in Northwest Territories, although I cannot say definitively that it is, but we are able, we're happy to look into that to give a better and more complete answer to that.
Question.
Yeah.
Let's say some people online or here know somebody else who's a 60's student. Can you leave me with some information?
Sure.
And then we will just, I'll drop by the Friendship Center, I'll drop it off there.
Yep, we've got
I can hand out some cards, business cards, pamphlets.
we've got these pamphlets, which are in the trunk of the car right now. Because I forgot to bring them in here. We also have a dedicated website for 60 Scoop survivors. So there's a lot of information on the website. There's some information on here. The website will also have links to all of the town halls that we've had. So we've had town halls in lots of different places in Ontario, Saskatoon, St. John's, a couple of different places in Labrador. Now here in, where are we? British Columbia.
We're going to Alberta next
We're
month.
going to Alberta next month.
Next month is Alberta. Yeah.
Likely Manitoba in January of all things.
Oh my God.
I know.
And
Don't get
Maritimes
me-
in the spring.
Maritimes in the spring.
Yeah.
Back to northern BC in the spring.
Back to
and
Labrador, none of it in the spring.
None of it in the spring, Yukon in the spring. So it's a road show, but all of the town halls, or the ones that at least we have been able to record without technical difficulties, are up on the website, so that, if somebody couldn't come to the one that was closest to them, they can at least listen to what was talked about there. They're almost the same. The information is the same, but sometimes people just want to listen to the community that they belong to,
Or our closest to,
or
yeah.
closest to. Yeah.
And if anybody needs anything from me in Kelowna area, you're welcome to call me. West Bank, 204-228-5435 is my direct number. 204-228-5435. If you just need to have a conversation, if you just want to talk to somebody, if you just need the lawyer's phone number. I know you guys are going to be on the road, so if I can assist in any way here.
Yeah, and we've got our people back at the office. I mean, at the office we have our intake specialist, who's actually a social worker, not a lawyer or paralegal or anything like that. She's a social worker who is wonderful at dealing with people and helping them breathe when they need to breathe.
Yeah. Good.
And we've got other lawyers. It's not just Ivana, it's also 3 other lawyers as well. And my group only does sexual abuse and physical abuse.
And
The-
primarily historic.
And primarily historic. The law firm itself also does, your typical personal injury things like car accidents and medical malpractice and whatnot. But my group, the 5 lawyers that are in my group, only do this kind of work. We are a law firm within a law firm, if you will. We also have forms that, again, are in the trunk of my car that people can fill out. And if they don't want to make that first phone call, if they fill out the form, we will call them.
Yeah.
It's just however it's easiest. The other thing as well is that, just because you call us doesn't mean you have to do anything.
Yep.
Right? Sometimes people get intimidated that oh, I have to call a lawyer, then I have to do it. No, you know what? Pick up the phone, give us a call. We can talk and go from there.
No charge, no commitment, like we just want people to know what their options are.
Sometimes it just starts out as a conversation.
For sure.
That's all it is.
Yep.
It's a simple conversation. And some people actually have an easier time opening up to a stranger than they do their family or their friends, because they're afraid of being judged, where a stranger would be like, okay, I'm very interested in listening to you. I'd love to,
Yeah. We have a lot of times we have people tell us that this is the first time they've ever told anyone. That happens all the time, where they pick up the phone and almost the first thing that comes out of their mouth is, I've never told anybody this, but.
this is what happened.
Yeah.
This is what I remember.
Yeah.
And sometimes as you talk, I have this happen to me sometimes where I talk out loud. It's like, I'll remember something else and be like, oh, I forgot about that.
Yeah.
Oh, yeah, that happened,
Yeah.
So it's
Yeah.
almost good to have those conversations out loud.
Yeah, I had
Absolutely.
in an interview with a client all of a sudden, and she thought she knew everything. She'd written actually a whole comprehensive story for herself already many, many years ago. She thought, and all of a sudden, we're having this interview, and she goes, "Oh, I have a new memory. It just came up.
Yeah,
Just came back to me."
Yeah.
yeah,
Yeah, it happens, and I think I think that's important too, right? Even
Yeah.
if all you're doing is talking about the same thing over and over. Like, I strongly believe people talk about stuff until they're done talking about it. So if you want to talk about it,
and just keep talking.
Yeah.
And keep talking, because I know for myself,
It's
I
therapy.
suppressed a lot.
Yeah.
And then it wasn't until my later years where I started talking about it to people and started getting involved at the 60 Scoop. And then it's like, oh, yeah.
One last thing. I know that we're primarily talking about 60 Scoop, but the things that we've talked about today apply to anyone. They're not just people who are 60 Scoop survivors. Whether or not you were a 60 Scoop survivor or not, if you were abused by an adult when you were a child, there may be something we can do about it.
Mhm.
A lot of the things we've been talking about are true regardless of whether you're Indigenous or non-Indigenous, status or not status. These are laws that apply to absolutely everybody in the same way. Indigenous people, they oftentimes, the harms that are caused are different, and that is taken into consideration
Mhm.
because of the fact that these are individual lawsuits. What can apply to one person doesn't necessarily apply to the other. The laws, though, are standard. The way that we pursue these cases are standard, but the information that we've given applies across the board.
we called it a 60 Scoop session though, because the class action really was not clear. So we
Was not
we needed to make sure that that segment of the community understood their rights.
Is that why you came across the country to do this?
Yeah. So about a year and a half ago, almost 2 years ago now, we were contacted by a woman named Colleen Cardinal, and Colleen runs the 60 Scoop Network.org in Ontario. And she had been abused in care. And
This is not a secret.
This is not a secret. This
Yeah.
is not confidential.
This is very public.
Oftentimes Colleen does the town halls with us. And she wanted to do something about her abuse. And she was referred to us by actually a mutual friend. Just so happened that we have, oddly enough, the same person as a friend. And in speaking with Colleen, it was so apparent that 60 Scoopers had no idea, or very, very few 60 Scoopers knew that just because they got money from their lawsuit, that they didn't, that they couldn't do other things. So in speaking with her, it became like, okay, this is information that needs to get out there. And we did our first town hall, much like this, very similar to this, also in a library,
Just about a year ago.
just about a year ago
Actually, just a little
now,
over a year ago.
in Ottawa.
Yeah.
In a library in Ottawa about a year ago.
Yeah.
And as a result of that, other people started saying, hey, can you do one in my community? Can you do one in my community? This, that, and the other thing. And that's how it's happened. And we've worked with the Healing Foundation. We've worked with Legacy. We've worked with the 60 Scoop Network.org. I can't remember what
It was
in Saskatoon.
It was the Métis Friendship
It's
Center.
the Métis Friendship Center in Saskatoon. and I can't remember the Southern Chiefs in Manitoba.
Manitoba, you might want to work with the Métis Friendship Center in Manitoba as well, in Winnipeg.
I
There's
think we
also-
may have contact with them. I can't remember.
Excellent.
So
Yeah.
that's how it's happened. Like people
Yeah.
sort of see it. They see it on Facebook and go, well, when are you coming out too? It's like,
Right?
yeah.
When are you
So-
coming here? You know?
Because, I have two clients specifically that I can think of that desperately want to talk to.
Okay, good.
Sure.
One, we've been looking for someone who isn't didn't take part in the residential school settlement, and he has been so wants to stay.
Perfect.
So he's looking for a lawyer to ask me for help.
Sure.
So we were struggling.
Yeah.
Trying to find somebody.
Yeah.
This is great. I'm happy.
Yes.
And offering services. Also, the second one I was thinking of is a 60's school survivor of abuse, and she's kind of, it's time sensitive for her. She is desperate to get it sorted out legally and get compensation because she wants to leave that for her children.
Yeah.
Call me. I will get you whatever information you need.
Yep, we're happy to have Stephanie facilitate too, or yeah, whatever's easiest for them. That's no problem.
For sure. For sure.
Yeah.
Or she can call your office directly.
Whatever's
Yeah.
easiest
whatever's
for,
easiest.
for her.
Yeah.
Or you can be in the room with her while you call us.
Yeah.
I think she'll probably want
That's fine. We often we'll have somebody in the room with them because, you know, we're not here.
And like having therapists and support workers, like
Always.
that's, yeah, that's not like, if that's something the person needs, no problem. It's whatever works best for them.
So your office is expecting people to call, like they're fully
We
ready to
are,
go?
We,
Just put you on the spot.
Since we started doing
Simona's
these,
like,
we've received a lot more calls. So we have, so our intake coordinator, she normally takes all the calls.
okay.
She expressed to us actually yesterday that she's starting to get a little overwhelmed with the number of calls that she's getting.
and by a little overwhelmed, a lot overwhelmed.
Yeah.
So we are
You know
actually,
your staff. Yeah.
we know our staff. We have, we have the resources to deal with it, in other words.
Yeah.
You know, we've got things in place to deal with people calling.
Yeah.
We find that every time we go into a community, even if one person shows up, the calls start. I mean, that's just how it works.
Mhm.
So we're ready for that.
Yeah, we're
Yeah.
equipped.
One of the things that comes across from time to time, I'm going to speak from the man perspective, and I think we talked about this last night. When, for men, for things to happen to men, it's hard for men to step forward and say, this is what took place, whether there's child sexual abuse with the male. One of the one I'm going to lead to now is the female.
Yep.
So we have people who are of age looking after children, and they're female, and they choose to play with little boys.
Absolutely.
And then what happens is it changes for the little boy his experience. It makes him
Absolutely.
sexually aware. I mean, he doesn't know how to respond to all these feelings he's had. And then, and so they're afraid to come forward to say, well, yeah, I was touched by a female and I need some help.
Yeah.
And so when you get the guys in the schoolyard, I remember for myself, when the guys talked about having their first touchy-feely with the girl, and I say, I got to be with you because when I was a little boy, my babysitter abused me. And for a long time, that was a badge of honor for me.
Yeah.
Until later on, when I got on to my healing, and I found out how much that hurt me throughout my whole life by being touched by a female as a little boy. So what I'm bringing this up is that we need to know, the men need to know to come forward.
Absolutely. 100%.
Yeah, I'm glad that you brought that up. You know, I can tell you that throughout my career, I have always had more male clients than female clients. Men seem to want to do something about what happened to them more than female clients. I can also tell you that there aren't very many female perpetrators. Most perpetrators men, not women, but there are women out there that do that as well. And we have had a significant number of male clients who were hurt by their female caregivers, their female teachers, their foster mothers, what have you. And you're right, it is different for men, especially in some situations where, you know, you've got maybe the boy is 14 and it's his teacher who's only 23, for instance, and his friends are actually egging him on that, hey, you know, she's hot, she's this, she's that, lucky you. It creates havoc within men. It is such a horrible thing to happen to a young teenage boy or a young boy to have that happen, because it has that social stigma and that social okayedness that you don't necessarily get with women or with teenage girls or with girls. And I think it's really unfortunate. It's something that we always try to deal with, because a lot of times the perception is that, oh, come on, it was okay, this, that, and the other thing. It's not. It is absolutely not. Any adult who touches any child, any adult who touches somebody who's in a position of authority, who touches somebody who is not, it is not okay. So I think you have a very good point. You know, men are abused by, you know, boys are abused by women too, and they need help and they need that help. And this could be part of it.
And boys are abused by men.
Boys are abused by men.
All the way around. Anyway, a child is vulnerable.
Absolutely, absolutely. You know, children are vulnerable. Children are our most precious gifts, and
Yes.
people take advantage of them all the time, and it is a horrible thing. So,
Any other questions?
I just had a scenario, I had another client who, I was really surprised that he came forward, so recently after it happened, where he was, sexually assaulted in one of the shelters here. And that's what was done. There was no, services for him, right? And, we were really like, just throwing nothing after it.
yeah.
And, wondering if now uses that. And never really, obviously, the shelter was responsible for who's in there. But yeah.
Good question. And we need to know a lot more about what happened before I can tell you yes or no.
Right.
Yeah. You know, in some cases, a shelter could be held responsible, and in other cases, they can't. You know, there are some very clear-cut situations. So to give you an example, if you were abused by a priest, a clergy of some sort, whether you're a child or an adult, if it's clergy that touches you sexually, there's really very little that the institution can do to get out of responsibility. Okay. In a situation like a shelter, it's not as clear cut. So we really do have to look at the individual facts. So, you know, to give you an example, if the abuser was a known offender and the shelter let them in and there were complaints and the shelter didn't do anything about it, you know, that can be a situation where the shelter will be held responsible. You know, it's very individual.
Yeah, I don't know if it was the same person who assaulted this client, but I've had multiple female clients say that they were sexually assaulted in that same shelter. One mentioned it was a staff.
Staff members might be a little bit different, you know. If it's a staff member in a shelter, that would be something that would be very important for us to know. If it's another client of the shelter, those are different circumstances.
But I mean, they're still responsible for allowing that client to come into stay in the shelter.
They are absolutely responsible for allowing that client to stay in the shelter, but that is not the only thing that's necessary to show legal liability on that shelter. We need to really establish what we call negligence, and that they knew or ought to have known that allowing this person into that shelter is going to create a situation where somebody will be harmed sexually. And that is not as easy as it sounds.
It gets tricky. Because
It does get
you wanna
tricky.
Make it a low barrier for them to stay in the shelter, but.
It-
Yeah, I mean, it's,
Well, they have a women's dorm and a men's, but if the men's is overfull and the women's is not, they would just.
This is where we would really need to talk to that individual to get more information before we can really say, yes, we think we can hold the shelter responsible. No, we don't think we've got the right facts to hold the shelter responsible.
Yeah, and stuff is often morally wrong, and it doesn't always appear legally wrong at the beginning, but that's where the sunshine breaks through the clouds sometimes, so.
Hi, sunshine.
I am so not sunshine. I am known as the curmudgeon.
It's true.
exactly what, oh, sorry, go ahead. No, 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 yeah, that's going on with the topic, so.
I was going to ask, people who were sexually abused by family members that went to residential school. They didn't go to residential school themselves. But they were sexually abused by.
Yeah.
survivors.
Yeah.
Is there anything we can-
Maybe.
So, this is one of those where it really is dependent individually. So for example, if they went home from residential school, they had children, and then child welfare became involved in the home, maybe we could say child welfare knew what they were like, or knew that they were suffering, or, maybe there was a police officer that, filed a report. Like there were so many, this is one of those situations where I have more questions now. Because if there's a way that we can make it clear that an institution failed that individual, that's what we're gonna see if it's a possibility.
But it wouldn't be something that we could go back to the federal government for because the perpetrator was a survivor of residential school.
Right.
That we couldn't do,
Okay. Even
unfortunately.
if they didn't participate in. Because they didn't opt out.
Yeah, opting out is something that in very, very limited circumstances, you can do what's called a late opt-out. But it's very difficult to do. Again, we would really need to know the individual facts.
That is so infuriating to me.
Don't get me started.
So
The
I
opting out thing, you have to know about it to opt out.
I
And
have
if
written
you don't,
many an article and many a blog posts about why that is just the wrong thing to do with abuse survivors. It actually imposes a limitation period where none now exists in most provinces. It is absolutely horrible. I think class actions for abuse are fundamentally wrong on so many different levels, but that is absolutely one of them.
Yeah, well, I mean, like you've said it multiple times, and I still haven't heard a good answer to this, but how are you supposed to give notice to somebody if they're living under a bridge?
Yeah.
Like and all of a sudden their rights are gone, like,
Yeah.
and they're not ready, and then 10 years later, they're finally ready.
Yeah.
And it's over, like, it's
Yeah.
just not, there's no good reason for that to happen.
No, exactly. And I mean, how many abuse survivors go through so long of their life, so addicted to substances that they really aren't able to function in any way, and they don't get notice. They don't see it, they don't know it, or they see it and it triggers them and they spiral downward for years and years and years. Sorry? So do we. Exactly. So
is there anything that can be done, like human rights side of things? Like I'm not thinking, do you know what I mean?
Simona's waiting for a person who can tolerate the amount of litigation that it's going to take to get the court system to change, because that's the tool that we typically use. So because we're litigation lawyers, like that's our job. So what we do is, and this is like something that, there's a problem in Ontario where employers can try to get out of liability for, sexually assaulting their clients. And I'm waiting for the right person who has that support system and that resilience and that ability to tolerate the appeals.
Let's
and
go.
the
You take as much time as you want. I'll sit here and fight right beside you until we get what we need.
See, but the people that have done that level of healing, most of the people who come to us, they're either midway through or partway through or just at the beginning or just ready to start. Not a lot of them are this far along. So for our tool anyways, the tool of litigation and the appeals at the Supreme Court and all that stuff, you have to have patience, you have to have stability, whether that's financial or emotional. You have to have some level to be able to talk, because it's going to be years, it may be decades. So anyways, that's, sorry, I didn't mean to jump. I get really excited about stuff, but.
I've already wasted 50 years, like they've already affected my life for 50 years. I mean,
Yeah.
I got another 50 years of fight in me. Let's go.
So that's, yeah, so that's part of it. I mean, there's lobbying, there's advocacy, there's, talk to your MP, there's lots of different routes to go about it, but our tool is litigation. That's our primary. Anyways, I don't mean to speak for you, but I get very excited about stuff, so, yeah.
She gets very excited about things.
And she asks a lot of questions.
I
It's
do
excellent.
ask a lot of questions.
We're gonna call you Curious George from now on.
No.
New t-shirt for you.
Hooray.
I think that, when it comes to 60 scoops, there needs to be somebody who is strong and who can stand up and not be afraid to ask those difficult, hard questions like, who is being held responsible for this?
Yeah.
Because those exact situations infuriate everybody. Who is being responsible for what has happened to the children after the residential school people came home? Who is being responsible for the 60 scoop all the way to the millennium? Really? You guys are just gonna keep doing this?
Yep.
No. Sorry, buck stops here. Mic drop. Done.
There you go. You're right.
Yeah, I'm just wondering what the responsibilities of the lawyers are for a class action, because I did register for the 60 scoop settlement. But apparently there was a second sheet I was supposed to fill in, and I was notified about that until after it was closed. So I completely lost out, just sort of who the hell put this program together? How come no one's looking after people that are signing up?
Correct.
And, I've left out in the dark.
So you know why there's a deadline, right?
Hmm?
You know why there's a deadline?
Mhm. Why?
So they can pay out.
Mhm. But I mean, I was way ahead, I did a good month before, or a good year before the cutoff. But I wasn't
So you
notified
should
that
still
there was a
be
second sheet
able
that
to.
was supposed to be filling out. And, no one contacted me about that, there was no follow-up, never heard a thing from them until after the court case was done. And I'm just sort of, this is garbage.
Yeah.
I got screwed. And I know I'm not the only one. I don't know who put that process together and why there were so different things to fill out for that thing, but.
So what we're looking at here is a program that was set up with the government, the federal government.
You are
They slapped
correct,
the
yes.
door on it. So what we're
Your
doing
mom and my
here,
mom
we're
got
just
together.
doing provincially.
Right.
So I did a lot of work down south and up north with people who were in the same situation. And the biggest thing we pushed for was to make sure everybody did all their paperwork, make that phone call, make sure that it's happening. And still people that got left in York like yourself. So now that's done. So now you're with us and you can step in and do a court action through the lawyers here and look at it from a provincial perspective.
Right.
That's right, provincial. That's where, so in the Canadian legal system, there's the federal government, there's provincial government, there's sometimes municipal government. So class action was federal, we're talking about provincial level. Because in the 50s, the provinces then became responsible for child welfare, and that's what gave rise, as you all know, to the 60 scoop. So provincial is right.
It was still their way to control the Indigenous people.
Mhm.
Just carried on.
And that's no different from October 4th, or just past the days,
Days
school.
calls, yeah.
There was
Yeah.
closed on October 4th.
I thought it was extended now to January.
I had not heard that. but
Oh, it
I
was
know that
extended
was
to
pushed
January?
What?
They
Day
were gonna
scholars?
close it.
Yeah, it was.
It was extended,
It was
yeah,
extended.
to January 2024.
So there was no announcements about that.
Right.
So
Yeah,
that's how the government sliced through.
Yeah.
So what we should do to support our sisters and brothers is no, we're not day schoolers, but we're gonna make sure we're gonna go through profile it with our community.
Yeah, it's the law firms that are involved in class actions are not lawyers that specialize or have very little, if any, experience in sexual abuse or physical abuse or childhood abuse
Or historic claims.
or historic claims. So they may be good lawyers when it comes to class actions, but they really have no idea how to deal with the cases. Class actions were never meant to be used for abuse cases. Class actions were designed for things like products liability, like, you know, your iPhone's battery doesn't work. You're not going to sue Apple because your battery's not working. But if every iPhone out there, if, you know, this model of iPhone, the battery doesn't work, you do it as a class action. So everybody gets their new battery and everybody's not suing individually. You know, that's the purpose of a class action. That's what they're designed to do. And they actually do that really, really well. Abuse cases aren't iPhone batteries. You know, abuse cases, people who are abused have very particular harms done to them and have very different requirements and needs, and need to be spoken to and serviced in a way that isn't the same as, you know, the person who just fills in the form because their battery is dying. That's really the only thing that I can tell you about why the class action settlement was done the way that it was.
I have a question. The residential schools, they already did their class action.
Yes.
Can they individually sue?
No. So the Indian residential school class action was actually done by personal injury lawyers, not
Okay.
sexual abuse lawyers,
Okay,
but at least personal injury lawyers.
okay.
So
So they got,
the big Indian residential school class action, when you look at the framework of it and when you look at the amounts that were paid out at the time, was actually pretty good.
okay.
You know, it wasn't perfect. It had a lot of problems to it.
Yep.
But it actually wasn't a horrible settlement.
Okay.
The process itself was frankly more humane than a lot of the other class actions that came afterwards with regards to abuse.
Okay.
But that class action did deal with abuse while in residential schools. So you can't turn around now and sue again.
Okay.
It's not like the 60 school class action that did not deal with
Excellent.
with abuses.
With abuse.
Right.
Okay.
And we're really sure the 60 scoop class action didn't deal with abuse. We checked the notice form to make sure, and it
There's-
specifically said no,
We're fine.
which is confusing because in the original lawsuit, it says people suffered abuse. The settlement had nothing to do with abuse.
Yeah, the settlement was, and that's because of the things that I talked about.
Okay.
It actually can't cover those things. I wanted to say something. but it's gone. That's right.
Any other
Is
questions?
the residential school settlement.
Right,
the community
yeah,
process.
the residential school, you know, one thing to also remember though is that notwithstanding that people that got their residential school settlement can't sue for what happened to them in residential school, if they were also abused outside of the residential school by, for instance, you know, the local priest, or after they came back from residential school and they went into, you know, a normal school, if they were abused by a teacher at a public school, that is still available to them.
Okay.
That is absolutely still available to them.
Okay.
It's just not harms that were caused while at the residential school.
Unless anyone online has any more questions, I will be closing the Zoom meeting in a second, but I think,
I think we're good.
all right. Thank you, everyone who joined
Thank
us.
you.
If any.